International law governs relations between states and other international actors. This includes topics like diplomacy, trade, and human rights. History and development of international law. Ancient origins. International law traces its roots to ancient civilizations, with concepts of treaties and diplomacy appearing in Mesopotamia and Egypt. Medieval period. The medieval period saw the rise of Christian international law, with emphasis on peace and conflict resolution. Modern era. The modern era witnessed significant developments, including the establishment of international organizations and the codification of international law. Sources of international law treaties. International treaties are agreements between states creating binding obligations for the signatory states. Customary international law. This is based on consistent state practice and the belief that such practice is legally binding. General principles of law. These are fundamental legal principles recognized by most legal systems, such as the principle of good faith. Judicial decisions and scholarly writings. These can provide guidance and interpretation of international law, but are not considered binding sources. Principles of international law. One, sovereignty states are independent and have authority over their territory and people, free from external interference. 2. Pacta sunt servanda. This means treaties are binding on states that have ratified them and must be honored in good faith. 3. Non-intervention states are prohibited from interfering in the internal affairs of other sovereign states. 4. Peaceful settlement of disputes. International law promotes the peaceful resolution of disputes through negotiation, arbitration, or judicial means. Dispute resolution in International Law 1. Negotiation states attempt to resolve their disputes through direct negotiations, often with the assistance of mediators or facilitators. 2. Arbitration parties agree to have their dispute resolved by an independent third party whose decision is binding. 3rd, judicial settlement. International courts, such as the International Court of Justice, adjudicate disputes based on international law. Subjects of international law. First-place states are the primary subjects of international law, possessing full legal personality and capacity to enter into treaties. International organizations. Organizations like the United Nations and the World Trade Organization have certain legal personality and capacity, often granted by treaties. Individuals. Individuals have increasing rights and responsibilities under international law, particularly in areas like human rights and environmental protection. Some example for international organizations and institutions. United Nations International Court of Justice, World Trade Organization, International Monetary Fund.